Hello, everybody. Hello, Ian Wilson. Thank you for joining me. Oh, hello, Ava. We're going to have to give it just a minute for people to realize that this is actually a live stream. Because, this is usually the time of day that I'm just posting the Replay Crew minis, and I very rarely come on live this time of day. But I have to make special exceptions when it's sovereign citizens. Yeah, Sov Cits get high priority on the list of things April does. So I'm also, having to, I exported it. It literally just finished. So I have to put it on the external and move it over. So 5 p.m. and it's noon here. Where are you? And happy Halloween to everyone. Oh my goodness. Everyone here in the States, I should say. Eva, okay, I guess, since it's a special occasion, I get ya. Special occasion. Oh, thank you so much for being a part of this. England, that is just beautiful. I can't tell you how much it means to me that I have friends from all over the world. Seriously, that blows my mind every day. Hi, cutie. Hi, cute pup. And I know everybody's usually here just for Ava, so. It's searching. It is searching on that other computer for the file. Because silly me, I got way too excited and I exported without looking where it was going again. Hello, Nigel1701. Hello, Sherry B. It's a day stream. I gotta, visit my day shift peeps every once in a while. And it's a sovereign citizen, so all the better. Yes, it is. Absolutely. Thank you for the rose, Nigel1701. We're just giving it a moment for people to realize that I'm live, and for, my computer to find the file that I exported, because I'm so good at this. Oh, yeah. We're having just the most blustery day. It's the wind is just terrible. Well, okay, it's beautiful, but all of the leaves are to the point where they're starting to fall off the trees with just a breeze. And so with it being super windy, all you see is just this cascade of leaves everywhere. And it was rainy yesterday. We had a big storm. I was going to go stay with Dad last night, but it was pouring. I could not drive in it. Bad enough driving at night when I'm tired, but then you add in the rain and my vehicle, my tires. Couldn't do it. Ooh, in the 80s. That's what yesterday was supposed to be for us. I don't know if it quite got that high. I found the file. All right. Yeah, 80s is a little on the higher side for me too. Alrighty, I'm transferring it over to my external, and then we'll be able to get on with the show. Oops. All right, here we go. And while it's going, I'm still gonna be, harvesting the dockets and, doing all the morning YouTubey stuff that you guys don't get to see, where I'm collecting stuff for you guys to watch. So you'll see me kind of paying some attention to the side there, and that's what I'm doing is all of that fun stuff. So let's get on with it.
Good morning, everyone.
Morning.
Good morning, Your Honor.
Good morning.
Good morning.
Good morning. All
Good
right,
morning.
a couple people have just joined in. Angela, do you have anybody else in the waiting room?
I do not.
All right, we'll go on the record. This is in the District Court of Butler County, Kansas. Case is entitled Board of County Commissioners of Butler County, Kansas versus Beverly A. Booker et al. Case number 24 CV 111. Ms. Kelly, you're representing the Board of Commissioners, is that correct?
That's correct, Your Honor.
Nikita Kelly, Counsel for Board of County Commissioners. I want to identify the other participants in the meeting. I've got D. Farthing. If you could state your name for the record.
My name is Donna Farthing. I'm the Butler County Treasurer.
Okay. And then at Court Security 1, what is your name, sir?
Sure. Roy Melvin of the family Moreland.
Melvin Moreland, and you are one of the defendants, is that correct?
Evidently.
Okay. And then
Hang on.
Sarah Birch Mackey.
Yes, Your Honor. I'm here on behalf of the United States and the Internal Revenue Service. And then the phone number that's showing up there, that's also the phone number that I've called in from. So I'm taking up 2 boxes.
Okay. So you are counsel for the IRS?
Yes, Your Honor.
All right. There are no other appearances this morning. Ms. Kelly, how are you wanting to proceed this morning?
Your Honor, there are still 7 properties that are in this tax sale at this point. 6 of which are in default, have not shown up. Mr. Moreland's property is the one that's in contest. So if it's okay with you, if we could just proceed on that property and give evidence as to the fact that the taxes are due.
Very well. Mr. Moreland, are you ready to proceed?
No, sir.
You're not ready to proceed?
No, sir.
Okay, and why is that?
I do not understand.
All right, what don't you understand?
The nature and cause of this accusation.
Okay, you filed a number of documents with the court, correct?
Yes, sir.
Okay,
And it was at this point Judge Crum knew exactly what he was in for.
so are you wanting a continuance or what? What's your
Well,
request?
I need to know how to defend myself. All these documents I filed was guesswork. I have not seen any evidence to substantiate anybody's accusation. And that's what I'm waiting on is evidence.
All right, Miss Kelly, you're ready to present evidence here today?
That's correct, Your Honor.
Okay. Well, we'll go ahead and proceed. And the commissioners are intending to present evidence this morning, Mr. Moreland.
Thank you, Your Honor. Plaintiff would like to call Donna Farthing as a witness. Miss Farthing, can you please state your name for the record?
I
Donna
don't
Farthing.
understand. Can this proceed and go on?
Excuse me?
If I do not understand the accusations, there's due process involved here. Now, do we continue this in violation of due process?
Are you requesting a continuance?
If need be,
Okay, what does that mean, if need be?
to give the accusers time to produce evidence to support their accusations.
That's what they're gonna do right now, Mr. Moreland.
Well, I need it in hand.
Pardon?
I need it in hand so that I can defend against it.
Have you requested any discovery?
No, sir.
Yeah, they're ready.
Okay, the petition's been on file since May 15th of 2024. I'm going to go ahead and we're going to proceed with the hearing, Mr. Moreland. You'll have an opportunity to cross-examine the plaintiff's witnesses. So, Ms. Farthing, I'm going to have you raise your right hand. I'm going to place you under oath. Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you may proceed, Ms. Kelly.
Thank you. Miss Farthing, could you please state your full name for the record?
Donna Marie Farthing.
And what is your current position with Butler County, Kansas?
I'm the Butler County Treasurer.
Okay. And in that position, do you have knowledge about cause of action number 50, which is in this proceeding?
Yes.
Okay. And could you tell me who are the owners of record of that property?
Ray M. Moreland and Barbara C. Moreland.
And is there any identifying numbers, such as a CAMA number for that property?
Yes. 328-27-00-02-001.06-0-001.
Okay. And that's referred to as CAMA number? Is that
Yes.
correct?
Yes.
And that identifies the property on the mapping records of Butler County, Kansas?
Yes.
Okay. And do you have a legal description for that property?
I sure do. It's the west half of the south half of the northeast quarter of section number 27, township number 28, south, range number 4 east of the 6th PM in Butler County, Kansas.
Okay. And is that property is situated then in Butler County, Kansas? Is that correct?
Yes, it is.
Okay. And as you're in your position as county treasurer, do you issue tax statements on a yearly basis?
Yes. Yes, I do.
And have tax statements been issued on this property?
Yes, they have.
Okay. And have those tax statements been paid?
No.
Okay. When is the last year that the taxes on this property were paid?
The first half of 2019 was paid, and that's the last one that has been paid. So it's the second half of 2020, or excuse me, 2019, it has not been paid, which put it in the tax sale.
Okay. And by put it in the tax sale, did the county bid it in pursuant to Kansas statute?
Yes.
And how does that procedure work?
So we publish that in the newspaper when it's delinquent, when it goes before it goes delinquent. We publish those 3 consecutive weeks in the newspaper. They were published on August 11th, August 18th, August 25th of 2020. And then they were bid off September 1st of 2020 to the county.
And that once they're bid off, does the redemption period begin?
Yes.
Okay. Has any redemption been made on these properties?
No.
No taxes have been paid for the 2019 second half, correct?
Correct.
And what about the 2020, 2021, 2022, and 2023 taxes?
No. No, this tax has been paid.
Okay, so the property has been held by the county for redemption for a minimum of 3 years. Is that correct?
Yes.
Okay. And how is this property classified?
Residential rural.
Okay, and so the residential classification, does that give it a tax rate of 11.5%?
Yes, it does.
Okay.
I wish I had a statute book.
That's all the questions I have at this time. Thank you.
All right, thank you, Ms. Kelly. Ms. Mackey, do you have any questions of Ms. Farthing?
I do not, Your Honor.
All right, Mr. Moreland, do you have cross-examination of Ms. Farthing?
Yes, I do.
Okay, go ahead.
There has been no proof of liability in these property taxes. Statement is not proof.
Well, that's all we are required to send out as a tax statement every single year. And they
Well,
have
I'm
it sent out.
Excuse me.
Go ahead.
Well, I'm required to ask for proof. Where's the evidence? It's not in that statement.
That the taxes are due or how much the taxes are. I'm not sure what you're asking.
Liability must be established in statute in order to make a person into a taxpayer, subject to a tax and against whom distraint or other enforcement may be instituted. I quote, liability for taxation must clearly appear from the statute imposing tax. From the Supreme Court in Higley versus Commissioner of Internal Revenue. A tax is a legal imposition exclusive of statutory origin. And naturally, liability to taxation must be read in statute or it does not exist. Bente versus Bugby. The taxpayer must be liable for the tax. Tax liability is a condition precedent to the demand. Merely demanding payment, even repeatedly, does not cause liability.
All right, Mr. Moreland, you'll have an opportunity to make legal argument right now. This is your opportunity to ask questions of Ms. Farthing, if you have any, based on the testimony that she provided.
Evidence.
Okay, you'll need to frame that in the form of a question to Ms. Farthing if you are asking her a question.
Ms. Farthing, excuse me. What evidence do you have that I am liable for taxes on this disputed, this dispute?
Well, statute 79-101, all property in the state and real and personal does not exceed exception, therefore shall be subject to taxation in the manner of prescription by this act. So the statute reads that the taxes are due.
Where's my land?
Ms. Farthing, could you repeat that statute number, please?
79-101.
Okay, thank you.
Mhm.
Does that cover land grants, Ms. Farthing?
I don't have the whole statute and I can look that up, but this is the piece of that says that the taxes are due.
But there's no classification for land grants.
I'm not sure what you're asking. I don't know what a land
Oh,
grant.
ma'am, as many years as we've been debating this thing and you know not, what's wrong?
I don't know what a land grant is, sir.
I find that unacceptable.
Mr. Farthing, you'll need to ask questions. You'll have an opportunity to present your case in due course. Do you have additional questions of Ms. Farthing?
No, sir.
All right. Any redirect, Ms. Kelly?
No, sir.
All right. Thank you for your testimony, Ms. Farthing.
Thank you.
Ms. Kelly, do you have additional witnesses to present?
No, sir, I do not. Thank you.
All right. Ms. Mackey, do you intend to present any evidence at this hearing?
Your Honor, I don't have any witnesses to present. We're here because we're also named as a defendant due to a federal tax lien on the parcel in question. And I would ask that the court accept the attachment to the Internal Revenue Service's answer, which is a true and correct copy of that federal tax lien with the taxpayer as Roy Melvin Moreland. And the United States interest in this hearing is that the United States interest be recognized in any journal entry in this case.
All right. Thank you, Ms. Mackey. All right.
Thank you, Your Honor.
Ms. Moreland, now is your opportunity to present any evidence that you may have. Do you have evidence to present?
Yes, I do.
Okay. Is that going to be in the form of testimony from yourself?
Yes, sir.
All right. I'm going to
Documentation.
if you could please raise your right hand. Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right. State your name for the record.
Roy Melvin of the family Moreland.
All right. You may proceed with your testimony.
I need one of those letters. There we go. This works. Miss Kelly, who's representing Kelly Law Office?
Miss Kelly is not a witness right now. This is your opportunity to present your testimony.
Well, Miss Kelly notified me several times with letters about delinquent and unpaid taxes. Now, every one of you should have a copy of this because I think I found it. But let me show you right up there in the corner. We can do this. Can you read that? Yes or no?
I can read it, yes.
So this is a debt collection action on all fronts. She says so. Please note that this is an attempt to collect a debt.
And
with
yet,
no proof. I have never, and let me rephrase that. I have always been willing to pay any tax I owe upon proof that I am liable. Now I've taken this thing to the top, the Board of Trust. Board of Tax Appeal. Through the local court, through the local appraiser. And just for example, my soul. These people are in default. I have asked time and time again for validity. And I have before me documents proving they're in default. I've asked questions and no answer has been given, which is due process violation.
Were your questions formed in the manner of something along the lines of, I am the living man and I do not understand, I stand under, and, you know, all the typical mumbo jumbo that we hear? Because they may not have recognized those as questions and may have just thought they were ramblings of a senile old man.
You've all got copies of this.
What documents are you referring to, Mr. Moreland?
Well, I should have brought some water. Before the Board of Tax Appeals, State of Kansas, summary decision. In that summary decision, the county appraiser offered evidence to the fact that this was income, that the liability was determined by income approaches to tax valuation. You look up income valuation, and there's got to be income from that property to be liable for any kind of ad valorem tax. That's the law, case law, court law.
Black's Law.
Do you have a specific statute cite, Mr. Moreland?
For
You just stated that that's the law. Do you have a
Federal
citation
Debt
to a
Collection
statute?
Federal Debt Collection Practices Act.
Do you have
There
a Kansas statute?
It follows the federal. Kansas statutes annotated 79-2015. Taxes may be collected in the same manner as a personal debt. Kansas enforces the Fair Debt Collection Practices Act. Kansans are protected under federal law. I have disputed the validity of this alleged debt for years. I have asked to see the proof that I owe an excise tax on my non-commercial private property. And I've already read the quotes on liability. A person must be liable for the tax, and that liability is found in statute. Tax liability is condition precedent to the demand. Merely demanding payment, even repeatedly, does not cause liability. I firmly believe I have the right to see the evidence used against me and to be able to challenge the validity of such evidence. I have never been presented with any sworn affidavits that would provide validity to the claims of county officials against my non-commercial private property. And as I said, I have the county's own documents are proof county officials' action is invalid due to the fact that statute which agency action is based is unconstitutional on its face and as applied. County officials have erroneously interpreted and applied the law, in particular KSA 79-1439, paragraph B, paragraph 1, paragraph A. Residential is a term in controversy. It is a material fact. Plaintiff has no facts and evidence to prove her claim. There is no relevant evidence in the record to support the county's claim that my non-commercial private property is connected to commercial housing, and that I owe an excise tax on income from commercial activity. County officials have not produced evidence to demonstrate by a preponderance of the evidence the validity and correctness of the classification or appraisal of my non-commercial private property. County action is based on a determination of fact that is not supported to the appropriate standard of proof by evidence that is substantial. If the debt collector has not supplied the demanded proof of the alleged debt within the time allowed, I may presume, under the doctrine of estoppel by silence, that no proof of the alleged debt, nor therefore any such debt in fact exists. Pursuant to the Butler County Appraiser's evidence submitted to the Board of Tax Appeals at the hearing in 2017, my non-commercial private property was classified as residential and valued after concerning its characteristics. I'm quoting now: location and highest and best use, the usability and adaptation to the cost, sales comparison, and income approaches to value. Income approach is particularly common in commercial, I repeat, commercial real estate appraisal conclusions of value for a real estate appraisal, and in business appraisal. Appraisers utilizing the income approach for reaching a conclusion of value for real property shall identify in the appraisal report the source of any income data that is used in the appraisal report. Where's the income? That question needs to be answered for this to be a valid proceeding. I have shown that the term residential used in the Kansas statute does not apply to my non-commercial private property. I have petitioned state and county officials to show the public interest in my land. I have petitioned state and county officials to show the privileged activity, event, justifying an excise tax on my land. My repeated petitions have been answered only by repeated injury. Ad valorem taxes. We need to get into the legislative history. I have been to Topeka. I have done the digging, and it's all commercial. Well, the taxation is commercial. Legislative history. The background and events, including committee reports, hearings, and floor debates leading up to an enactment of a law. Such history is important to courts when they are required to determine the legislative intent of a particular statute. Legislative intent of an ad valorem taxes in Kansas is to tax economic growth and business development. I've got the legislative history to verify that. KSA 79-1401 indicates Kansas employs a uniform method of taxation on property. Uniformity applies to excise taxes. Excise tax is a tax imposed on the performance of an act, the engaging in an occupation, or the enjoyment of a privilege. The apparent target of ad valorem taxes in the state of Kansas is income from commercial activity and is subject to an excise tax. Ad valorem taxes are contingent on use value. The government's alleged claim is my non-commercial private property is used for residential purposes, i.e., that is commercial housing enterprise with a profit motive.
When was the last time you had your property zoned, sir? It might be zoned as a commercial property, whether you're using it for commercial intent or not.
Ad valorem taxes in the state of Kansas are taxes on the income of commercial activity and does not apply to my non-commercial private property. I quote from Redfield versus Fisher. The individual rights to live and own property are natural rights for the enjoyment of which an excise cannot be imposed. Pardon me, my mouth is starting to stick again. In fallow, well, that's due process. All right, let's get into the land patent.
The land
This is
what?
my land patent.
Land
This is good.
patent.
Land, L-A-N-D, patent. Oh, is that the mic? I didn't know.
All right, I got it. Go ahead, Mr. Moreland.
1998, I believe it was. I filed with the Bureau of Land Management the patent to this property. And
Oh,
I
boy.
received the patent. I spent years in the Recorder of Deeds vault downstairs digging out the chain of title to my property. And that chain of title is immune from any sort of attack. It's untaxable. And these tax liens by the IRS are illegal. Pursuant, and this is Miss Mackey's territory, I believe, correct? Federal tax liens. Hello.
Mr. Moreland, you're providing testimony. You're not asking questions at this time.
Tax lien rebuttal. Pursuant to the Federal Tax Lien Act of 1966, the lien provisions of the Internal Revenue Service are to conform to the concepts developed in the Uniform Commercial Code. The Uniform Commercial Code is legislated law that sets down the rules for all commercial transactions. Pursuant to the UCC, there must be a valid UCC-1 on file, which is shown the alleged debtor's signature and the creditor's signature. There must be a security agreement signed by the debtor, the alleged debtor, and the secured party, and there must be a valid court order wherein the alleged debtor has had due process opportunity to contest the alleged debt. I have seen no valid court order, no valid financing statement, nor a UCC-1. I have been shown nothing with my signature on it that would validate government claims. It's very important to realize that neither a notice of lien nor a notice of levy issued by the Internal Revenue Service is valid absent a valid court order signed by a judge. The claim that arises from 26 U.S.C. 6321 is in short until there is a judgment from the court of competent jurisdiction, and any voluntary levy, seizure, garnishment, or other adverse action predicated on the inchoate lien is a nullity, as it is condemned by the Fifth Amendment Due Process Clause. Notice of federal tax liens, notice of levy, and other such instruments utilized to encumber and convert private property are uttered instruments unless perfected by a judgment issued by a court of competent jurisdiction. The statutes named in these tax liens do not apply to Roy Melvin Moreland nor his land. Use 26 U.S.C. 231, 2321, 26 U.S.C. 2322, and 26 U.S.C. 2323. I am not personally liable. There is no valid assessment that makes me liable for a tax on privileged taxable activity. I am not an officer, employee, or elected official of the United States, nor am I a federal employee, state and municipal employee, or seaman. Material facts are undisputed. Also listed is U.S. 26 U.S.C. 1040. I am not acting as a fiduciary or an executor for the estate of a deceased person. That is what that statute is for. 26 U.S.C. 6682, I have made no statement that did not have a reasonable basis to it or was materially incorrect. That statute covers frivolous arguments, and I have never made a frivolous argument. I have always backed up my statements with valid evidence. 26 U.S.C. 6702. I have presented rational arguments based on court admissible evidence supporting my claim. Material facts are undisputed. The only way the Internal Revenue Service or any other administrative office or agency may administratively enforce collection instrument without a judgment from a court of competent jurisdiction is when the target of the collection action knowingly and intentionally waives his substantive rights and thereby consents to administrative collection. Waiver of constitutional rights not only must be voluntary, they must be knowingly intelligent acts done with sufficient awareness of relevant circumstances. I have never knowingly, willingly, or voluntarily surrendered any of my constitutional rights. My property is not property subject to lien levy because there is no evidence that I am the subject defined in the law as the government agent engaged in a trade or business. The term trade or business is defined at 26 USC 7701 parentheses A, parentheses 26, includes the performance of the functions of a public office pursuant to USC 26 USC 6331 parentheses A. I am not an officer, employee, or elected official of the United States, the District of Columbia, or any agency or instrumentality of the United States or the District of Columbia. Furthermore, pursuant to 26 CFR 301.6331-1, parentheses A, parentheses 4, parentheses I, and 26 CFR 70.611, pardon me, paragraph A, paragraph 4, paragraph I. I am not a federal employee. And then pursuant to 26 CFR 301.6331-1, parentheses A, parentheses 4, parentheses 2, and 27 CFR 70161, parentheses A, parentheses 4, parentheses 2. I am not a state or municipal employee pursuant to CFR 31301, that dot 6331, paragraph A, paragraph 4, paragraph 3.
I suddenly have that Billy Ray Cyrus song stuck in my head. I'm pretty sure it was Billy Ray Cyrus. I love you, period. Do you love me? Question mark. Please, please, exclamation point. I want to hold you in parentheses. Yeah, that one. Yeah. For some reason, that's now going through my head.
And I'm not a seaman. Internal Revenue Service sanctions are procedurally and substantively incorrect. Procedurally, Internal Revenue Service sanctions against my property were filed in violation of the Federal Tax Lien Act of 1966. There is no supporting documentation validating IRS claims. Substantively, Internal Revenue sanctions against my property are in error. In the title, it says Internal Revenue Service sanctions are against a small business employer, self-employed. Wish I had my note. Internal Revenue Service sanctions cite statutes that apply to privileged corporate activity.
Mr. Moreland, this is an action from Butler County against you. The IRS is here because they have a lien on your property, but they're not. This isn't an action regarding that lien. This is regarding the taxes being assessed by Butler County.
Buried in here, but bless your heart, sir. Pardon me. It's dry. Well, still, excuse me. I still have a land patent and chain of title. A grant of property made by the government is one or more by the government to one or more individuals. After exclusive jurisdiction over lands within a state have been ceded to the United States, private property located therein is not subject to taxation by the state, nor can statutes enacted subsequent to the transfer have any operation therein. Supreme Court decision Surplus Trading Company versus Cook, Western Union Telegraph Company versus Childs, Arlington Hotel versus Fant, Pacific Coast Dairy versus Department of Agriculture. Security and land rights was and is found within a treaty. And I've traced my land patent back to the treaty with the Osage Indians. Canville Treaty, September 29th, 1865. Drum Creek Treaty, September 10th, 1870. Osage Dominion Reserve and Trust Lands, 1870. My chain of title to the original land grant is based on a treaty. The Constitution of the United States, Article 6, the federal document not subject to state taxation. It is a federal document not subject to state taxation. It, the state or county, may not tax the patent rights, but it may the income of the patentee derived from the sale of patented article. Now there's the rub, ladies and gentlemen. Let me repeat that. It, the state or county, may not tax the patented rights, but it may the income of the patentee derived from the sale of patented article. Supreme Court decision Dobbins versus Commissioners of Erie County. You cannot, my land grant cannot be taxed. Any income from that land can be. Now, witnesses against me say I'm having income from that property with no evidence to prove their claim. There is no income. And I have judgment defaults. I don't know if it's worth doing on Butler County. Butler County officials' action is arbitrary, capricious, and abuse of discretion, and otherwise not in accordance with law. Butler County officials are acting contrary to constitutional right, power, privilege, or immunity. Butler County officials have acted beyond the jurisdiction conferred by any provision of law. Butler County officials are acting without observance of procedure required by law. Butler County officials have erroneously interpreted or applied the law. Butler County officials' action is based on a determination of fact made or implied by that is not supported to the appropriate standard of proof by evidence that is substantial when viewed in light of the record as a whole. Again, I have shown that the term residential used in the Kansas statute does not apply to my non-commercial private property. I have petitioned state and county officials to show the public interest in my land. I have petitioned state and county officials to show the privileged activity event justifying an excise tax on my land. My repeated petitions have been answered only by personal injury. All right. One of the documents, K79, KSA 79-1606, appeals to hearing panels or officers, procedure and disposition. I read from paragraph D. It shall be the duty of the county or district appraiser to initiate the production of evidence to demonstrate by a preponderance of the evidence the validity and correctness of the classification or appraisal of residential property or real property used for commercial and industrial purposes, except that no such duty shall accrue with regard to leased commercial or industrial property. No presumption shall exist in favor of the county or district appraiser with respect to the validity or correctness of any such classification or valuation. The burden of proof is on the county to show that I have liability. Butler County is in default with my affidavit of truth and assertory oath. I filed this in March of 23.
We have an affidavit of truth. It was coming. It's here, y'all.
It's my affidavit. And pursuant to law after law after law, well, where did it go? An unrebutted affidavit stands as the judgment. Glory to God. Glory to the Lord. Where is the other? You must forgive me, people. I do not know how to defend myself until I have time to see the nature and cause of this. And so this is the reason for why this pile of documents. I'm just unsure how to do it. But I'm doing it.
You're doing fine, Mr. Moreland.
Thank you. So are you. Someone.
I cut out some
Unrebutted
very
affidavit.
long pause breaks.
Glory to God. Well, you know, the ingredient is hid itself. Excuse me. Here we go. I found one. And I repeat, on March 20th, 2023, I filed an affidavit of truth and notice of superior claim. My affidavit of truth and assertory oath has not been rebutted. An unrebutted affidavit is prima facie evidence in this case. Uncontested affidavit taken as true in support of summary judgment. And I'm just reading a few of the court cases. The Superior Court of the San Bernardino County, 207, uncontested affidavit taken as true in opposition to summary judgment. Silence can only be equated with fraud where there is a legal or moral duty to speak, and where an inquiry left unanswered would be intentionally misleading. We cannot condone this shocking behavior. This sort of deception will not be tolerated, and if this is routine, it should be corrected immediately. U.S. versus Tweel. So whatever action may be taken, you've already agreed. You've agreed that I have reserved the right not to be compelled to perform under any contract or commercial agreement that I have not entered into knowingly, voluntarily, or intentionally. The Constitution of the state of Kansas governs the assessment and taxation of all properties subject to taxation. Pursuant to Article 11, Section 5 of the Constitution of the state of Kansas, no tax shall be levied except in pursuance of a law, which shall distinctly state the object of the same, to which object only such tax shall be applied. The law is to distinctly state the object of the tax and only applies to that stated object. And I could go on. Well, gee, yes. We got any statute books handy?
We know you can go on.
Hang on. I'm looking for 79. 1439. I got it here somewhere. Too much. Case in point, Kansas statutes annotated 79-1439. I cannot remember the paragraph, the section, but it defines residential. We have a statutory definition of the term residential. And I'm doing it from memory. Residential means multifamily dwellings, mobile home parks, etc. Point being, residential, the term residential does not apply to my property and is mislabeled.
So if it's not residential, then it's commercial. Argument solved.
By officials that my property is used for multifamily dwellings, used for daycare centers, used for commercial activity, activities for profit. That's the definition of the term residential. Now I challenge you to prove me wrong. As far as your debt collection, this is a debt collection action. And now that's how I am pursuing it. And I have proof upon proof upon proof that nobody nowhere at any time has verified debt that I owe. Well, dig myself out from under all this. That's all I have.
All right, thank you, Mr. Moreland. Ms. Kelly, cross-examination.
Yes, Your Honor, thank you. Mr. Moreland, what is your property used for?
It's where I live.
Okay. And did you hear the treasurer testify that it was classified as residential?
Yes.
Okay. So no, have you been told that your property was classified as commercial? Is that correct?
No. By definition, my statutory definition, the word residential it means commercial.
When
So
you, okay. First question, did you pay your taxes for the second half of 2019?
I believe so, under duress.
Okay, the treasurer has testified that you did not. Do you have a receipt or anything showing that you did?
No, I stand corrected. That's what I thought she said. I stand corrected. No.
Okay, did you pay your taxes for the tax year 2020?
No.
Have you paid your taxes for the tax year 2021?
No.
And have you paid your taxes for the tax year 2022 and 2023?
No, I am not liable for these years of taxation.
And if you are to read, which you have cited, the Constitution and KSA 79101, which codifies it, all property in this state, real and personal, not expressly exempt therefrom, shall be subject to taxation in the manner prescribed by this act. Can you tell me if you have an exemption order or anything from the Court of Tax Appeals or any court that exempts your property from taxation?
It doesn't matter if he reads it or not. He will misinterpret it and then spew it back to us as word salad and verbal vomit.
That's irrelevant. I've not thought any state granted whatever. We're talking
So-
about,
Your property is not exempt, is that correct?
that's a tricky question.
Is your
I said-
property exempt from taxation?
By virtue of the land grant, yes, ma'am.
Did you buy your property? Who did you buy your property from?
Lewis Simmons,
Okay. In your deed, did it say anything that was being transferred you to pursuant to a land grant and that the United States retained exemption or any type of control over that property once it was transferred?
I'm sorry, I didn't understand.
Do you have anything in your deed that says the United States is retaining any type of ownership over your property? Or was it transferred to you in fee simple?
Please repeat again. My mind is,
Is there anything in the deed that you have in which you got ownership of the property that states that the United States still has control over that property?
I do not have the deed. I have title. I have transferred deed to title.
Okay. Do you have any documentation showing that the United States still has control over your property?
No, ma'am.
Okay. And if I'm trying to understand what you said, you believe your property is not residential property, is that correct?
Correct.
If you read KSA 79503A, it says real property shall be assessed as to subclass at the
It's not-
following percentages of value. Real property used for residential purposes, including multifamily residential real property necessary to accommodate a residential community of mobile or manufactured homes, including the land on which they sit. So, how is your property not residential property if you are living on the property?
It's not right. I'm sorry. I can't find my copy of 79-1439.
It's 79503A. 1439 is an equalization appeal before the Board of Tax Appeals. We are not before the Board of Tax Appeals. 503A says real property used for residential purposes
Uh-oh. She prepared.
shall be taxed at 11.5%.
You say it's real property. I say it's private property. And I have proved you're wrong. It's private property under the protection of a federal land grant.
It's real estate, is it not?
No, ma'am, it's private property.
So it's personal property. It's like a table or a desk.
Private property.
Okay. I also would like to ask, you have alleged that the county did not file an answer or a response to your document that you filed as an answer in this case. Is that correct?
Yes, ma'am.
Did you not receive a copy of plaintiff's response to defendants Melvin Moreland's and Barbara C. Moreland's counterclaim?
Yes, and I don't have that before. Forgive me.
All right, so you did receive a response.
Yes, but her responses was not in line with the law. And I don't have it before me, and I cannot argue that point. I'm sorry.
You've also stated you filed an affidavit that was uncontested in March of 2023.
Yes, ma'am.
Okay, this case was not initiated until May 20th of 2024. So how is that possible?
The issue is taxes. So anytime an affidavit I filed was regarding property taxes. So it's relevant. Excuse me.
But it was not filed in this case, is that correct?
I do not see how that has bearing. It's on file.
Understand that this is a petition for tax foreclosure.
Right.
Okay, do you understand the county is requesting that its lien on your property be foreclosed and that the county be given the authority to sell your property in satisfaction?
I have seen no lien from the county.
It's a statutory lien. Did you at any time try to redeem your property by paying these taxes?
Not since I became more educated in law.
Do you understand the difference between in rem and in personam?
Yes, ma'am.
Do you understand this procedure is in rem against
Yes,
the
ma'am.
property, not against you personally?
Yes, ma'am.
Okay,
And that property is protected from all intruders.
and do you have any proof of that?
Land patent signed by Chester A. Arthur in 1883, I believe it was.
So is it your position that any property that was originally owned by Native Americans is exempt?
By virtue of treaty. It's
Okay,
treaty law.
I, at this point, don't have any further questions. Thank you.
All right, thank you, Ms. Kelly. All right, Mr. Moreland, do you have any further witnesses or evidence you wish to present?
Can't dig it out. No, not at this time.
All right. Ms. Kelly, I'll give you an opportunity to make a brief closing argument.
Thank you, Your Honor. The county has attempted to the best of its ability, or I have on behalf of the county, to reply to Mr. Moreland's contentions. And from what I can get out of it, he is contending that the court of Butler County, Kansas does not have jurisdiction. I have filed a plaintiff's response and set that forth, and I'm not going to reiterate it here, but it is our position that, yes, this is in the proper court and is the proper jurisdiction for a tax foreclosure. He also has said that the county has incorrectly valued and classified the subject. The testimony of Ms. Farthing shows that the property was classified as residential, and Mr. Moreland has also substantiated that he uses the property as his residence.
Correction? No, that's false.
You'll have an opportunity to make a statement, Mr. Moreland.
He's also said that he was not given due process of law, which we're here today, and meeting that requirement for the due process of law. So the county at this point is simply asking for judgment in rem for the delinquent taxes, to foreclose its lien on these taxes, and to have the ability to sell this property at tax sale pursuant to KSA 792801 et sec, in order to attempt to satisfy its lien for the delinquent taxes. Thank you.
Ms. Kelly, the response that you've referred to, my file is 2 volumes thick. Do you know the date that was filed offhand?
My copy, I don't have the file stamp date on it. I could pull it up fairly quickly.
If I knew the date, that would help me more easily
Yes, I understand. Let me try to,
locate it.
take me just a second here on the e-filing system. It was
Where's Constitution?
It was filed on 6/27/24 at 11:17 a.m.
All right, thank you. Give me just a
welcome.
second here. All right, Mr. Moreland, I'll give you an opportunity now to make a brief closing statement. You don't need to go back over all of your position. A closing argument is just a brief summary. So if you'd like to provide that, I'll give you that opportunity at this time.
Thank you. I found my copy of 79-1439. The appraisal of real and tangible personal property at fair market value in money, exception rate of it. And it says down there in, well, I'll be doggone. Real property used for residential purposes, including means. Real property used for residential purposes means multifamily residential real property. Property necessary to accommodate a residential community of mobile or manufactured homes. Real property on which such homes are located, residential real property used partially for care home purposes if such home has been registered with the license pursuant to KSA. Real property used for bed and breakfast purposes. By statutory definition, my property is not residential. And county has no claim to it.
All right, thank you, Mr. Moreland. Ms. Mackey, do you wish to make any further statements to the court?
Just briefly, Your Honor, thank you. The United States is not seeking affirmative relief in this action, but rather is asking that its valid federal tax lien be recognized in any journal entry or judgment foreclosing on the property in question. To the extent that Mr. Moreland has made statements to the effect that there is not a valid federal tax that is owed, this court is not the proper forum to present any such arguments, and this court lacks subject matter jurisdiction to hear that. So we would ask the United States lien be recognized on the property in any journal entry and judgment of foreclosure. Thank you.
All right, thank you, Ms. Mackey. All right, I do find that the court does have jurisdiction as the property in question is situated within Butler County pursuant to KSA 79-101. The court finds that the property is properly classified as residential property, as Mr. Moreland testified that it's his residence on the land. There's been no evidence presented of any statutory exemptions that would exempt the payment of taxes on this property. The court therefore is granting the relief requested by the Board of County Commissioners. The court will direct that the United States tax lien be recognized in the journal entry.
Question. If this court does not have jurisdiction over the federal, then why is this federal tax lien being introduced?
Mr. Moreland, I've made my ruling. If you wish to appeal my decision, you can appeal this to the Kansas Court of Appeals.
Okay.
All right, Ms. Kelly, do you have any questions?
I don't, Your Honor. I'll prepare a journal entry and submit it for signatures.
All right, Ms. Mackey, do you have any questions?
No, Your Honor, thank you.
All right. Well, thank you, everyone, for being here this morning. If there's nothing further, we'll be in recess. Have a good day.
Thank you. Thank you.
117. I've missed you. Oh my gosh, you guys, that was so much fun. Oh, yes, he had it so wrong. Exactly. You know he's gonna appeal it. Of course he will. With his affidavit of truth. Oh, I'm so happy to see you, Katrina Rosmierek. And you, Chris Barton. You are always such a ray of sunshine in the comments. Earl is making his special debut. Earl Grey, you need to back up from the camera. You're looking like those defendants who give us nothing but their earshots. You're handsome, though. Handsome boy. Oh, Ardo, you are such a charmer. I just love you. Ain't that the truth? Oh my goodness. Yeah, thank goodness he's one of them that doesn't use those on me anyways. Billy's always giving me love bites. And Tiny Kitten Esquire just doesn't know any better yet. Tiny Kitten Esquire is really good about it though. Like he plays with stuff and accidentally bites me, but it's never like thinking I'm the toy or, trying to play with me and as a toy, I guess it's hard to explain. It's always accidental, like, going after the toy and getting me instead. Billy, on the other hand, he'll be like, ooh, mom's a jungle gym and mom's a chew toy. You taking off, Sherry B? I'm so glad you joined. The day shift is so much fun. I wish I could get on more often during the day. But, as RC117 pointed out, life is tough. It's a struggle. It's hard. So, yeah, unfortunately, it's really hard for me to get on during the day. I make special exceptions for Sov Cits like that one. That's what Billies are. For the most part, yeah. Yeah. And then I just take him and put him right where he's at right now. Yeah. I set him there and then he just lays down and gives up because he realizes he's not going to get it. I think Esquire might be past that point, and because it's not an all the time thing, and she's not like chewing on stuff often. She is, those foam pads that the talking buttons are put in. She has found that she can peel where the buttons go. There's little stoppers in there, space holders, and she has found that she can peel those out. So that's the new thing with her right now, is every time I go in the kitchen, there's a massacre of little button spacers. You just can't help yourself, can you? You're acting like you never get attention unless I'm streaming. Like, this is the only time I ever pet you or play with you is right now. And you are so lying. She really is. She really is. Earl is very handsome. He is such a sweetie. He's the kindest, most gentle of all of the paw pets that I have here. He really is. Billy is the resident a-hole. But I love him. He's my baby. And Tinykin Esquire, she is my underfoot kitty. I cannot walk without her doing figure eights on my legs and standing in front of every step. Like, and the only way to stop her is to pick her up. And that's exactly what she wants. Because instantly, you know, I'll pick her up and hold her and she's going, you know, it's like, yes, I know. A shack? Tony Brown, you give him so much credit. Hello. Oh yeah, can't you tell? Can't you tell? Hey, Ava, it's officially Halloween for real this time. Well, you know what else would help? Me. They are really the best friends. And they're funny. They make me laugh all the time. Especially this one. They all have their own personalities. Thank you so much, Tony Brown. You just keep reminding everybody. And y'all just, I don't know what you got to do. I don't know what the YouTube-y stuff wants, but share this. If you guys are like in the actual court chats, not on other people's channels, because I don't feel right about that. But if you're on, like, hypothetically, like Travis County arraignments or something like that, you know, and you're in the chats, bring me up. Tell people to come watch me and just share me. And I don't know, Twitter or X, I guess it is now, Facebook, whatever. If you have friends that you think would get a kick out of this stream and these babies, please share it, because, you know, I would love to have more friends here and let everybody know that I'm on late nights, you know. I'm who you look for when you've got to pee in the middle of the night and then you just get stuck on my channel. That's typically how it works. But I'm not complaining. RC117, I love you. I hope you know that I really do. And I'm so glad to see you. It's been forever. All right, guys, I don't have anything else prepared. I literally kept watching the download of that until it finished and then instantly just did a quick edit to remove some of the spaces. Most of what I watched with you guys, I hadn't even seen because it was such a quick process to get it out to you guys. And so I have nothing else yet. I may have to go stay with Dad. I talked about that last night at the end of the stream. I may have to go stay with Dad. So I don't know if I'll even get back on tonight, but I'm certainly gonna try. But I'm probably if I go see Dad, I'm gonna have to pack for several days because I'm gonna have to stay there several days. So, but the good news is I can do this anywhere. You know, I can edit and stream from anywhere as long as I have a decent enough Wi-Fi connection. So hopefully I'll get back on tonight. But if not, just know that I love you all and I will be back as soon as possible. I'd go crazy if I couldn't. Absolutely. You guys keep me sane. Trust me, when it's just me and 3 cats and a dog all day, every day, with no human interaction, I would be losing my mind. You guys keep me sane. I will. Oh, he was overwhelmed with the love and support from all of you guys. He couldn't believe it. I was telling him that you guys were all praying for him and that he was getting so much love from the channel, and he was just like, really? He's like, tell them I don't take that lightly. Oh, Chris Barton, thank you again, sweetie. You are so wonderful, and you're always leaving me such amazing comments. And I know those comments help the YouTube algorithm as well. So everybody, the replay crew mini comments and the comments after the live streams, YouTube takes those as how many people are interested. And that's how they choose which videos they're going to push out. So the more you comment, the better. And you have a wonderful day. Thank you so much, Jenny Green. Oh, for you. All right, Ava, I need my hand. I'm sorry. I need it. Here, how about this? I'll trade you a biscuit for my hand. Fair trade? All right, guys, I got it back. Probably not for long. Thank you all for coming and hanging out with me. That was so much fun. Be safe, be well, stay sweet, and much love.